Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Yesterday, we discussed the second Balaji case. First Balaji is S. Subramanian Balaji versus State of Tamil Nadu, which gave rise to the discussion on the freebies or free gifts. The second case is very famous case A.K. Balaji or Bar Council of India versus A.K. Balaji, in which the topic of foreign lawyers, whether foreign lawyers are entitled to practice in India. Ultimately, the decision is that they can fly in and fly out, but they cannot set up a regular practice in India. Now, we are discussing the third Balaji case. This is M.R. Balaji case. So, Subramanian Balaji, A.K. Balaji, and now we are discussing M.R. Balaji. This is a reservation issue. You can read the case as M.R. Balaji and others, actually and 22 others, versus State of Mysore 1962. Actually, M.R. Balaji and 23 others. Actually, 17 persons belonging to engineering admissions and 6 persons belonging to medical admissions. They have filed the writ petition. Numbers 90 TO2 112 by 1962, and ultimately this was decided by the Constitutional Bench of Gajendra Gadkar, Shah, Vanchu and others on 28/9/1962. This is a landmark judgment, particularly as regards discussion on the reservation. Please remember, debate on the reservation. This is one of the landmark cases. Actually, you may be knowing the case of Champakam Dorai Rajan versus State of Madras, 1951 case. That's also actually, that has triggered the opposition to the reservation, due to which the first amendment to Section 50, Article 15 has come into existence. 1951, that's the first case, Champakam Dorai Rajan. We will discuss that case also. So please remember, this judgment gave a lot of discussion on the reservation system. Please remember, you may be knowing, equality among the citizens is the most important, effective or objective of the Constitution of India. Equality, you may be knowing, Article 15, it prohibits discrimination of any person basing on the race, sex, religion, caste, all these things, right? But please remember, there should be a reasonable or protective discrimination. So first of all, as far as Article 15 is concerned, there should be no discrimination. But how to uplift the poor? Therefore, so actually there was a proposal. Actually, Government of India Act, as per Government of India Act and Article 46 of all things, the Government of Madras, yes, they have reserved almost 78% or so for the backward communities and no reservations for the Brahmin community. This was challenged by a medical college student, an aspiring medical college student, Champakam Dorai Rajan, and you can see the case as State of Madras versus Champakam Dorai Rajan, 1951, right? So please remember, the admissions to engineering and medical college based on the caste, definitely it is not appreciable. It was challenged, of course. Here, the government of Madras, they contended that under Article 46 of the Constitution of India, which tells about the social justice, they have taken action. But Supreme Court, no. The government order is void. So it led to the First Amendment, or Article 15, Clause 4 has come with that only. Now, later, and the Supreme Court said the directive principles of state policy cannot override the fundamental rights. Right. So now we are coming to the later, 1962. After 10 years, M.R. Balaji and others, they filed a case. The genesis of the case, better you know, or facts of the case. Please remember, on 26/7/1958, the State of Mysore, they issued an order or a GO. So placing all communities except Brahmins, they're also same thing. All communities except Brahmins in the category of educationally and socially backward. So who are they? Backward caste, STs, and 75% reservation was given to all of them. That means merit pool only 25%. Right. This was challenged by different persons. The court has struck down all these things, and the government has been giving various the so-called percentages of reservation. Now we are coming to 1962. In the year 1962, the Mysore government once again issued an order. So regarding the reservation of the seats in the medical and engineering colleges, classifying backward and most backward and more backward and more backward categories. So for all these people, reservation of 68% for BCs, more backward, SCs, STs. So in the admissions of engineering and medical college, it was 68%. And what about the leftover? Only 32 for merit pool. So is it not unjustifiable? So therefore, this M.R. Balaji, who is an aspiring candidate for medicine, and others, they have filed the writ petition. Already I told you the numbers, 90 TO2 112 by 1962. Right. Already I told you 6 engineering medical college and 17 engineering college students. Right. So here the government of Mysore or state of Mysore, they contended under Article 340. So under Article 340, yes, the government can appoint a commission to study the conditions of the backward communities, and they can give recommendations. So basing on the so-called Article 340, they have enhanced the reservation up to 68%. So this is contended by the state of Mysore. Please remember. And they also stated that as per Article 12, state is definitely defined. Yes, Mysore state can give the so-called orders. So please remember. But here the important point found by the constitutional bench is the government relied on the caste factor. So they have categorized the BCs solely on the basis of caste. But please remember, Article 15, Clause 4 deals with the class, not caste. This is an important point. Please remember. Article 15, Clause 4 deals with only class, not caste. But here the reservation is based on caste. So please remember that too. Another sub-classification, BCs and more BCs. This is also nothing but unjustified. It is not justified. So please remember, as regards the percentage of reservation also, Supreme Court said that 68%, please remember, in engineering and medical college would be a fraud on the constitution. Please remember these words. It is a fraud on the constitution. Reservation should not exceed 50%. Ceiling limit has come. This is the best judgment for this. So the reservation should not exceed 50%. Therefore, they allowed the writ petition. Of course, even though this judgment has been overturned number of times, but it is a classic case, classic judgment which has given rise to the discussion on the reservations. Please remember, it is a landmark discussion on the so-called reservations. 50%, whatever reservations are there, it should not exceed 50%. This is the crux of the issue. So with this, all these three Balajis are over. I think you might have understood, but please remember all these three judgments which are very, very important judgment. With this, I want to stop. Thank you very much.